expert, where some person that's got expertise in that area may serve 50 different law firms, just to throw that number out there. And so you have limited contact with that person versus, and I don't know if it's good or bad, but there's a guy just about halfway down the hall from me who's our CIO. So if I ever have a question, I can just go darken his doorway. It's what he gets paid to do all day, every day. And he's a great resource, but that's not something that's available to all of us. I get that. And so hopefully what comes from our work will enable you, no matter where you're perched and no matter what your work circumstances are, to be able to get the benefit of what it is that will unfold as we populate the things that we've got to populate in the inquiries that have been posed. Obviously, we got a brief overview of this as state bar counselors in the January timeframe, and Evan was kind enough to assemble this nice packet that's chock full of great information about this issue. I hope all of you have read it or skimmed through it, but I would love to hear the perspectives of the folks that are on this Zoom call today about the topic that we're going to be addressing, whatever opinions you might have right now. So I'll just kind of turn it over to any of you who'd like to kind of pipe up and share anything that you've got in the way of commentary about the work we're about to undertake.
So I guess I have a couple things. I think that we're really talking about two issues, right? It's the preventative side. What can a lawyer do to prevent the data breach, and then what happens in the event when there is one. So I'll just share, I mean, we're a smaller to mid-sized firm. And so, our experience is, we do have some IT help, but I think in our area, like we're one of the only ones that have kind of consistent IT help. So really kind of want to speak up and for the little guys that, may not have everyday IT help. A lot of our county is solo practitioners, and I think that's going to be something that's really important to take into account. And having our firm experienced an incident, I guess you could say, and it was lucky that it wasn't worse than it was, but just the incredible, manpower that it took. I mean, we had a phishing email go out in a matter of 5 minutes. It was shut down. That wasn't the issue, but everything that happened on the back end took an incredibly long time to handle, and just kind of being cognizant of that as well, I think, are my general top level things I think we should be thinking about.
Well, you're absolutely spot on in terms of the analysis that you gave, Kristen, because two of the inquiries deal with, okay, how do you stop this from ever happening in the first place? And that's ideal, right? You'd like to never have these issues kind of confront you or your fellow lawyers. And then if you do have a compromise of your system, what can you do in the future to avoid it? So those are, I think, very, very important things, and will help lawyers across the state, as you say, no matter what their circumstances are. So other thoughts, comments, or observations?
So I'm at the city of Raleigh, and as you might expect, we have a very sophisticated IT department, and each individual department has additional IT folks in addition to a big umbrella. So they sometimes will do things like phish us for fun, like we get fake emails and we're supposed to click on them. And so, we're fortunate to have a sophisticated system. Although when I worked for the city of Durham, we were the victims of a malware attack, and the city's documents were locked up for a week or maybe even 2 weeks. So, there are some interesting issues that come with being the custodian of public records, and which I know are not, germane to small law firms, but just thinking about some of what other legal requirements there may be for some of our documents as the government, and just want to commend Evan. I thought the inquiries and the answers were really a great framework to start thinking about this. So well done. Thank you.
I agree. And I mentioned a little bit, but so I work with Hatley Law Office, who's based in Chapel Hill. They operate under iticket.law. They only do traffic tickets. They're pretty much online based. They've got their whole staff in Chapel Hill, and they have a local attorney in each area who handles their traffic tickets. I'm that for Columbus, Bladen, Robinson, and Brunswick. We have an IT staff. We watch training videos on popular phishing attacks for our, all these things that I feel like is pretty routine in the larger firms. That was a shock to me because I've been with iTicket 6 years now, but I'm like applying that to the firm, which is my father, myself, and one paralegal. I'm like, oh, should look out for that. We should be doing this because it's not really in our rural area. I mean, I think, let's say there's 40 lawyers in Columbus County. Um, our firm and three others have a website. I mean, so it's just like the just huge disparity of how these different firms practice and just operate day to day. And speaking to how Craig mentioned, I mean, if I get an email that looks suspicious, I can literally yell and say, "Hey, did somebody send me this link?" And I'll find out right then. But I think that I love the idea of how can we guide people to keep this from happening and giving realistic steps, not holding the 2 or 3 man law firms to the standards of these huge, they're not going to have an IT staff. They might not even have an IT guy, but like give realistic steps. These are concrete things that you can do to prevent this. And if it happens, here is the most helpful way we know to protect our clients and protect the information that you've still got. So I really appreciate what everybody said because I think for me it's been really eye-opening because I have the unique perspective of being on both sides of that coin. And I do worry a lot because we honestly still do a lot on paper for that reason. For criminal cases, discovery is sensitive. So we keep it in our binders. For everybody's social security number. The clerks are responsible for removing it from all our filings, but I worry so much that something's going to fall through the cracks. So I'm excited to learn from everybody. I really liked the roadmap with how we've started, and these statistics are wild. Just looking over what a huge impact it does have is sadly not that surprising, but just to see them in black and white is really eye-opening. So I'm excited to see where we go.
Thanks for sharing.
So, this is Lori. I have a small family law practice in Wake County. We don't have an in-house IT department, but we do have an IT team that we work with. So, that we contract with, and they're responsive. We have not had an electronic data breach, but we have had a um, which is, I think it's why it's important to think of this beyond the context just of an electronic data breach. We had a sensitive information that was filed with the court. And now that we have e-courts and everybody can look at everybody's information, um, there is an organization or a website out there that takes things that have been filed and it republishes them. So even if you get an order to seal, that information may have already left left the scope of where it was intended. And um, so I think that the family lawyers have had a lot of discussion about, what do we put now in our pleadings? What should we leave out? There have been, some, uh, we were required to put in social security numbers for a long time for divorces. And well, now with e-courts, that's really kind of a scary thing to do. And same with attaching documents to our pleadings. Say, for example, we're seeking a restraining order and we want to show somebody emptied an account. Well, we need to think twice before we're actually attaching evidence of what we're talking about. And also with HIPAA and medical issues that we may have in our pleadings. So I think that there is like a confidential or privacy button that comes along with filing things, but we have found that that doesn't really work so well. So, information is getting out there that wasn't intended for everyone. And, we're notice pleading requirements. So we have to put some details in about things, but trying to balance that against privacy concerns that come along with e-courts. That's been a new road. So I think it would be helpful to have some guidelines that don't just apply to data breaches that are electronic, but that can be applied in a broader sense as well. Just, the inquiry, number one, what's a lawyer's duty to protect against data breaches? So, when we're writing these things up, should we be filing everything confidentially? Should we be automatically seeking protective orders or orders to seal at the front end, which really kind of flies in the face of open courts, right? So it's all a balance. So that's it.
Well, thank you for bringing that to our attention. I think to the extent that somebody can access information through a third-party vendor that's providing the service you've described that could be very detrimental to a firm or to somebody, that's something I think
Yeah.
we need to kind of engineer around if we can, for sure. So, this is a crazy thing, but I don't do residential work, but up until fairly recently, it was not uncommon on a deed for a lawyer who prepared the deed to put the social security numbers of the people who were the grantees or the grantors. And you just go, oh my gosh, nobody would do that now, I hope. But it's the public record in every state of the union is littered with deeds that reflect the social security numbers of the parties involved in real estate transactions. It's just shocking. So, okay. Anybody else want to offer their perspective on these issues?
I can go, Craig, if that's okay.
Yeah.
I wanted to come back to something I think it was Kristen raised just about the maybe goals or organization of the opinion. I agreed with her observation that it might be good, I think, and it is written this way, to start with just duties around having some security and good practices, kind of irrespective of whether you ever have the fun of notifying of a breach. And a nice clean separation so people don't feel like those duties arise only in case of a breach, right? And then within the actual breach response, I think a lot of good points are raised in the inquiries and opinions, but thought it might benefit from untangling a little bit the response where you are trying to understand what happened and make it stop versus what was affected and do you have to notify. You're doing a little bit of that both all at once, but I think for purposes of discussing duties and approach, it would be more straightforward and easier for the reader to understand if we tease that out a little bit.
Good point.
Does that make sense so far?
Mm-hmm.
Okay. Agree with Lori and had jotted down, we might hopefully briefly raise and address paper. My example was more like a clean paper incident. We've had clients where they left their binder in the airport bathroom or on the airplane. They had a mismailing and everybody got everyone else's info. And I think that would raise all the same types of obligations we're trying to talk about. But if we're covering them well enough and in a neutral way, we maybe just, point out that paper is still an issue. Sometimes, often the attackers are after money, not data. So you alluded to an incident type where the attacker will get into the email account. And the point of that is not usually to steal your email. The point of that is to find your invoices and use your email account to send what look like proper invoices, but with the wrong wiring information so that they can get paid. And we've had a lot of folks misjudge that that is just a fraud financial incident and not think about all the email that was read and accessed along the way as more of a data breach. So I don't know if there's a way to address, like, my point is the lawyer might need to think about whether what felt like financial fraud actually involves some of these obligations too. Or it's helpful to think about like where your risk is. It's not necessarily just the data, if that makes sense, if you're engaged in a practice that involves wire transfers, for example. Somebody, I think it might have been Lori again, touched on laws that apply here. I think we probably don't want to get into that. You all can let me know if I'm wrong, but maybe just mention that besides the ethics obligations, HIPAA came up. That's right. They have a breach notification obligation in there. All 50 states have one. They run based on the residency of the individual whose data was affected. So that's a total pain. Like it won't just be North Carolina, maybe, but like maybe a quick mention so the lawyers know to look at that, but this committee not trying to, give that legal advice or unpack all those laws. And then last, I wondered what folks thought about raising insurance coverage. I don't want to try to sell insurance for anybody, but it's an important mitigation to recover financially. And they come with somebody like me and usually a security expert who can investigate. That's not to the proactive stuff, that's to the responsive stuff, but it might be worth a thought for firms, even small practices, to get a policy like that so that they have some backup. But I'm not sure if that works in the context of a ethics opinion to raise it.
Well, I'm not so sure it's not something that we ought to raise because I think it's something that can protect people.
Yeah.
It's available. It's expensive, but it is available and can help mitigate whatever harm results. And I know, Elizabeth, somebody told me one time when you're wiring money, you always need to verify those wire instructions by somebody at the recipient level, because the only time you shouldn't do that is when you want your money to go to China or to a malefactor.
Yeah. Yeah.
And
Don't just do whatever it says on the invoice.
correct, correct.
Yeah. So back to the insurance, I think they're not inexpensive, but I think the pricing can vary based on the risk the insurer perceives you to be. So that can also, I think, be like Tara, for somebody like you guys, if you don't have that much personal data, they might view you as not a big risk and give you a better price, or the opposite of that. But it's definitely cheaper than paying out of pocket for some of
Yeah.
what's common.
And I think a lot of firms, I mean, I would not have any clue that that type of insurance, I mean,
Yeah.
maybe ignorance, but I mean, until I dealt with iTicket, I just was like, oh, that makes sense. I didn't know this type of insurance existed. And I would think a lot of my colleagues in rural counties, it just
Yeah.
hasn't come up. Thank God. We don't want it to come up, but I think that a lot of people would like the information so they can at least do
Yeah.
the work and make an informed decision on whether it's a good fit or not.
That makes sense. And Evan, help me. I thought, did Lawyers Mutual come up in here somewhere, or did I dream that?
And there's a
Yeah, there's just kind of a nod to a kind of checklist, quick list that they have
Oh, that's
for
right. A
putting
resource.
together like a
Yeah,
kit for how
right.
your firm should look at IT risk.
Yeah, and that reminds me, Craig, I feel like somewhere in here you mentioned bringing other people to help. If that's a thing, I think that, so I do this work sometimes for law firms, not usually under an insurance policy, but Will Quick at Brooks Pierce does. Um, so if folks are open to other perspectives, he might be useful to have for that reason. My perception is he'll have assisted more law firms or lawyers than I have, by contrast.
good.
I was kind of thinking about what Tara was saying and about having, some people, it just the concept of a data breach, hasn't really come up yet. And it would be helpful, I think, to maybe provide some kind of examples. Like for example, a phishing email, right? And I know in our area, I've seen like social media posts like, oh, if you got an email from me, just disregard it, right? And, the particular attorney may or may not realize that that constitutes a data breach and what kind of information may have been accessed, even if it just was a phishing email. And so I think kind of, giving, a checklist or a flow chart type, step 1, 2, and 3. But the first thing is, correctly identifying if you have a problem and what kind of problem you have. Because there's just so many different, ways that you can be attacked out there.
I agree, because it's kind of like, oh, this is weird. I'm sorry that went out. And then you hold your breath for a month, or you sit and say, well, nothing happened, so it's probably fine. So getting people to like pointing out this still is a breach, or is it, or what should you do next if this happens, even if you're lucky enough that there is not some type of fallout.
These are all great thoughts. And I think, we talked about in the agenda, trying to identify some best practices. And I think these are all things that'll enable us, I think, to put in written form what some best practices would be. And I know, Elizabeth, you kind of went through a bunch of them together, and that's very, very helpful. And I know in our firm, it's kind of like what you were saying, Anna, where you might get tested, and it's something where it's not announced, but you might get an email, and if you were to click on the attachment, you immediately get enrolled in a little remedial course on how to detect and to address anything that's kind of unusual. And I think it's helpful. You don't want to be in that class, but it's important because really, no matter what size your firm is, it only takes one person to compromise the entire enterprise by doing something that they shouldn't. So we really all need to get schooled up. And I know one of the things that I had kind of run by Evan and Britt was maybe having one of the people who was a part-time, not part-time, but a fractional type of IT consultant. I've talked to our firm's head of IT. He's all on board and would be, I think, very excited about participating and helping because, as I mentioned earlier, sometimes within the field of law, whether it's a firm, a third-party provider, whatever, an email that comes from somebody within that universe can really cause there to be a huge problem for a law firm by doing the wrong thing in connection with what looks like a valid email, say, or a valid attachment. So I know I'm getting ahead of myself a little bit. It seems like that's probably something that there's a underlying feeling that I'm detecting from the people here that might be good. And maybe we get somebody from the legal field itself who helps firms that experience these things to kind of join our merry band as well.
Well, can I check, Craig? What did want to ask about that? So I could be voted off the island, but I guess I'm worried about us trying to describe all the best practices in this written opinion. Like we'll be here for a year and then it won't be right anymore. You know what I mean? So how do we, like meeting all together for educational purposes would be helpful and good. I just want to make sure I understand the line to what we would actually try to state in the opinion, or maybe we.
Yeah,
I was
can,
wondering,
Okay.
I can jump in for this one because we talked about it a little bit yesterday, kind of internally, and really thinking about the opinion as overarching guidance where it likely will not hit every single potential fact pattern issue. Because like you said, as a group of lawyers, we can be here till 2020, 8, thinking of all the various ways something could happen and then all the various solutions to that something. So really what we want to think about is how do we structure an opinion that irrespective of the scenario, a lawyer can take a look at it and say, how do I deal with what just happened? Or
Yeah.
how do I prepare myself for what could happen? And I think, to Tara's point, thinking about how that looks across the breadth of attorneys. The two-person firm, we might have best practices that only work for the firm that's, grossing $1.1 million a year. And the two-person firm will look at those best practices to say, if that's the best practice, I might be doing, mediocre at best because I can't do that. And so it's really thinking about, in the opinion, how do we write one that can hit the breadth, but maybe also considering that may look different across a spectrum of what, attorneys may deal with based on where they practice, how they practice, the size of their firm, the access to resources that they have. And so, kind of thinking about all of that, not getting too granular, but ensuring it's sufficient guidance that helps the attorneys.
Well, I can only speak for myself, Elizabeth, but I think if you had just a very short list of the top problems that you might encounter, that would be a good thing to include if we think it's appropriate. And I'm not speaking for the entire subcommittee here, but this is an issue where it's kind of like trying to shoe a running horse, because the bad people, they're not satisfied with where you are now or where firms are now. They will come up with other creative things that allow them to compromise systems. And so what you do today and what you're flagging for people today may not prevent something a year from now. But and this is just what I have gleaned, and I'm no IT expert, but I think the single most problematic thing in terms of data breaches is when somebody clicks on an attachment to an email that they shouldn't have clicked on. They shouldn't open it. And that probably is the number one thing. So I think, again, we can perhaps consult with some people who apply their trade in this arena and can advise us better. But from what I have seen, that seems to be the very most problematic thing from a data security perspective. Somebody opening an email they should not open, or I'm sorry, opening an attachment to an email that they should not open. So I don't think we ought to try to be comprehensive. I don't think we can be, but I think we can have, a short list of things that just are so common that it'd be great for our 10,000 some odd law firms and individual practitioners over and above that in North Carolina to know about. So that's what I would envision, but we can kind of figure that out along the way, I think. Well, anybody else want to offer insights? Got about 20 minutes left here.
Yeah, if I could add, and it kind of goes back to something Lori had noted about protected documents, documents that may be behind, confidentiality orders. Was having a conversation with another attorney, kind of just about this topic generally. And one thing the opinion does not consider, and it may be just because I couldn't find specific rules or nor did I see other states consider it, but conversations that you may have with the judge or opposing counsel if this were to happen, particularly if you do have some of those confidential or protected documents that have been accessed, where what comes into play if, like, hey, you may have business trade secrets of opposing counsel's client. Where do you contact opposing counsel? Where do you inform a judge, like, hey, I know you put a protective order on this information, but this information ended up becoming accessed in a data breach? Judge, do I need to tell you that immediately, or do I tell you if it gets out? And so I don't have an answer, haven't researched that yet. But it could be something if you all want to think about that, because our rules may not necessarily speak to exactly what happens, but do our rules give guidance as to how a lawyer should consider more than just the duties to their clients, but in just the administration of justice generally? Is there some duty when a data breach impacts the other side or if it impacts the courts?
No, I think that's good because
So
normally
I
you're
do think,
adverse, right? I'm sorry, go ahead. Go ahead.
this is Lori. So I do think that that's important to address because we're facing that more and more in family law. And I'm sure other areas have as well. But I know for us, getting to the judge was actually not an easy situation. And I had a former judge who was opposing counsel, and he and I were working together and made sure, we had to file a motion and get it, because the judge just wouldn't meet with us to deal with it, to close the file. We had to jump through some procedural hoops, and some judges may not have made us do that, but because of the procedural hoops, it caused delay. And so, if I were going to add somebody to this committee, it might be somebody associated with e-courts or the judicial system, or somebody who could help address when emergent action needs to be taken due to the public nature of e-courts. I mean, not that it wasn't public before, but you actually had to go down and check out a file. Now it's just out there and so easily accessed, and there's really no delay in people grabbing that information and running with it.
Mm.
So,
Good idea.
and from the lawyer's perspective, what do you have a duty to do? It is, notice given, and then, what ability do you have to reach out to a judge in some manner other than a motion and notification to clients, and that's all as important as if it were an electronic breach.
And you also raise a good point where you may be in an adversarial relationship with another attorney, but it needs to turn into something collaborative in the event that there's some data breach that you have to work on together, right?
Yeah, I mean, there's a common goal to protect information. So, and I find that the lawyers I work with in Wake County are generally agreeable and amenable to resolving those types of issues. I don't know how, I hear not some stories about other counties, but I would think that everybody would want to work together before fingers start being pointed. So
the good news is none of us practice.
Get pointed out. Those fingers get pointed later.
None of us practice in New York, where I think perhaps civil means less civil than it does in North Carolina. Just saying. So
yeah,
I think that that's a good point, though. Any other thoughts, comments? Okay.
Greg, I just wanted to comment something that you said and that Anna just talked about, that, we have in the past invited non-lawyers professionals to participate in our subcommittee meetings. So having an IT professional, she mentioned an AOC, someone from AOC. So I just wanted to let you know, it's like we've done that in the past many times. And then the other thing is, to Evan's point about duties to third parties, we touched on it in 2006 Formal Ethics Opinion 10 with regard to HIPAA and confidential medical information of the opposing party. So that opinion doesn't really flesh out the issue, but it might be something to look at and then to consider whether or not in this opinion we should flesh it out a little bit more to explain those obligations.
Well, and that's related to that. Can I ask? I was assuming that maybe the smart play is to mention that laws might apply here, just so we don't give anybody a bum steer, but not unpack how a different statute or regulation might obligate somebody to prevent or notify of a breach. Is that right, or is that wrong?
Yeah, Elizabeth. Yeah.
Sorry.
I was saying, in the draft opinion, I do note the North Carolina Identity Protection Act, I believe is what it is, without going into detail. Just hey, if this occurs, go look at this statute to see if it applies to
This is
you.
not it. Yeah. That made sense to me. Okay.
And that's what we usually do. Like if we know that there is a law out there, then we will just refer a lawyer to the law, but without giving any explanation about the law, because we don't give legal advice. So that's informally as well as through a formal ethics opinion.
Right. Okay.
Yeah, and so Evan, I did see that, and to my earlier comment about HIPAA, like that we just maybe like open it up a little bit. It's not just the one, but like maybe that's an example, and then it's good, I think.
Yeah.
Okay, thank you for that.
One other thing I'll mention in inquiry 5 at the end of the document that Evan prepared, he does address the insurance aspect of protection in the event of a data breach. So, but I think that would go a long way toward making people feel a little bit more comfortable that it's always better to spend other people's money than your own.
Yeah, and what really made me think about it were the comments about, you know, how do you get this expertise? And having someone with actual forensic experience who just swoops in and starts the investigation because your insurance triggered it is pretty helpful.
Mhm. Yeah.
So that's one way to get at the expertise, just not in a preventative way sometimes.
Well, I know that one of the things Evan mentions, and he included in the backup materials, is that we all have this duty to kind of have some working knowledge. And I will tell you, my working knowledge, I'll just be honest, is very limited because I rely on somebody else to do the things that I need to have done. So I think, Nicole, your point about perhaps having somebody from outside the practicing of law world would be good, just because I think the world's changing. I think these things are going to become more and more important. And having that perspective, I think, would be good because most of us are kind of dialed into our practice. We're not necessarily reading a lot about IT and about preventative measures and the things that are really kind of front and center in terms of trying to protect your enterprise in this day and age. Um, Let me ask one question here. Got about 10 more minutes. How many of you who are practicing use engagement letters when you retain a new client? I know we do. Okay, most of us. Anyway, I think there's a duty that we ought to also impose on our clients to make sure that when they are communicating electronically, whatever system they've got and whatever it is that they do, is designed to prevent the kinds of issues that we talk about in the parade of horribles in the draft inquiry with opinions that Evan put together. That's for another day, but I think most of the engagement letters I see include something about that. And, you know, when we are talking about duties, rules to consider, potential gaps, that may be something that we want to address during the course of our work, Evan. Just a thought in terms of how we're not the Lone Ranger here. Things can happen to our firms or our practices because of things that our clients might do, and we need to try to safeguard against that. So. Okay, well, I know that I can get a guy named Skip Lohmeyer, our CIO, to be part of our group. I think, who was it that mentioned, was it you, Anna, who said that you guys have somebody who kind of offers insights to your fellow workers about data breaches and how to avoid them? I know others of you mentioned that you have access to a IT person, but maybe they're not on staff. But I think that would be another good person to include if we can identify somebody who serves lots of smaller law firms. But that's just my thought. I don't know if anybody's got thoughts about that, but I think that's a whole nother world, right? You're talking about a universe of a lot of lawyers in North Carolina who don't necessarily have full-time support for IT. So I think that'd be a good perspective to bring to the table.
We have someone who is in the building, in our building sometimes, and then not at other times. So if you would like, I mean, I can reach out to him. That kind of, he sort of fits the category that you were just describing.
If you don't mind, Kristen, I think that'd be helpful. Yeah.
Okay.
Again, we've got a population that we're trying to serve that's going to be all across the spectrum for sure. So, okay.
Craig, I suggested Will Quick for the reason that he actually counsels law firms and lawyers on what to do when this happens. If that might be duplicative of us. He's another lawyer, but if you want, I don't mind asking him if he's got
Yeah,
time.
why don't you? Because from what everybody described their practice looks like, it didn't look like his. And I think, to the extent that this is the world that he lives in, I think it'd be helpful to get his perspective if everybody's on board with that. So if you don't mind making the inquiry,
Yeah.
that'd be great.
Okay.
Good. All right. Any other individuals or people that could be external to the bar or to uh, any of the practices that we are involved in who might be an asset for us to reach out to?
I know Lori mentioned either like e-courts or somebody from the judicial side to consider, those issues as well. I don't know of anyone specifically that we could ask, but I mean, I don't mind doing some research unless somebody else knows someone to just go to, but I think I can find a connection.
I'm
That
sorry, Evan, what was it?
Someone from e-courts.
Oh, uh-huh.
The disclosure of items that you think are maybe confidential in the context of public filings with courthouses. I think from what Lori described, it's happening with regularity, and to the extent we can bring somebody in from that universe, that should be helpful, in my opinion. Okay, thank you, Evan, for offering to do that. Hope you're able to identify somebody quickly. Okay, let me see if there's anything else that we ought to talk about for the good of the order here before we go. I do want to talk about our meeting schedule, just because of the experiences I've had on the various subcommittees that I've been part of at the state bar. I guess if all of you can maybe report offline to our group, if you've been able to, get people like Will or like Skip Lohmeyer in my firm, or the person in your building, Kristen, who does this for different law firms, I think that'd be great. And we can make sure that we get them on the agenda and have them appear before all of us at the appropriate time.
Yeah, if you can identify those people and then get that information to Britt, with their contact, like their email contact information, so that she can help organize and when she sends out the doodle poll for availability for our next meeting.
Good. Okay. All right. And by all means, if you have a pearl of wisdom that comes to mind when we're not all together, feel free to share it. I think a lot of times those things just kind of come to you at the times you least expect. But this is a meaty topic. It's something that affects really all the practitioners in the state. And so don't be bashful about sharing that whenever it comes to you. The one thing I did want to talk about is meeting cadence. And this is just me. And I'll be interested in what others think, but I think if you have long gaps in between meetings, it's something that can be inefficient, where you kind of got to get back up to speed where we left off. And so my preference, and this is just my preference, would be meet more frequently than not. I think if you're trying to do it once a quarter or once every couple months, that can be problematic. And Evan, I'd be interested in your take on that, but I'd be also interested in everybody else's take on that. But I think if we can move things along quickly, that's a good thing, and it'll benefit all of us. So I'll just be quiet and listen to what all you have to say.
Yeah. So Craig, and he had asked me, my thoughts, and I think it's easier to schedule meetings and then cancel as needed than to cancel or than to try to schedule them later, and finding difficulty. But I think there's a lot of momentum and a lot of interest in this topic that even if we're doing some of this information gathering regularly, and then maybe as we get into more of this substantive writing portion, we may not have to meet as often because it may just be, me doing writing and you all, putting input in. But I think to your point, Craig, for some of this information gathering, because of how quickly things change, we could meet this month and then by next month, a topic changes because something new happens. I support the idea. And then, like I said, if we're in a scenario where we need to cancel a meeting or we don't think we have enough meat for a meeting, cancel it for there. But yeah, open to other people's thoughts.
I'll just throw this out as a suggestion. Obviously, there's another meeting of the State Bar Council in April, kind of, I guess, in about the third week. And if we could meet during that first half of the month of April, I think we would have maybe something where we're a little more fully informed and can develop a report that I think would be a little meatier than we're in a position to deliver today. But again, I welcome people's thoughts or comments or ideas about that.
Let's do it. That's a great idea.
All right, good deal. All right. Well, I'm glad you all are on board. I think working at a pretty good pace is something that will benefit all of us. That's just my opinion. Okay, well, Britt, if you could maybe circulate one of your polls that kind of targets that time frame for our next meeting, that would be great.
Absolutely.
To the extent that you get confirmation from any of the people that we've talked about who could be good additions, let Britt know that as well, so that we can maybe include them in the polling. And we'll have a meeting date hopefully where everybody can attend, and that would be helpful. So, anything else, Evan or Britt or anybody who's on the screen for the good of the order before we call it a day today?
Well, I think I feel good, have good notes, and we'll pull all of this together. And then as some of those names come in, we can see who we can get on this next meeting.
Okay, outstanding. All right, well, I look forward to working with all of you. You had great ideas today, and this is not a subcommittee I would bet against. So, all good.
Thank
All right.
you.
Well, we'll see you all soon, and
Thank
thanks
you,
again.
everyone.
Thanks.
Bye-bye.